The applicant, Grace Nabunya and Samuel Katumba versus Nakaseke Bright Future Secondary School. Applicant.
May it please this honorable court. My name is Juliana, the senior counsel for the applicants. Along with me, my lords, is my co-counsel, Alana Chirabo. We shall divide this honorable court's time as follows. I will use 10 minutes to handle issue 1. My co-counsel will use 8 minutes to handle issue 2 and reserve 2 minutes for rebuttal. My lord, I maintain that this honorable court has unlimited and original jurisdiction as provided in Article 139 of the Constitution. In addition,
we have
my lords, I maintain that this High Court has unlimited and original jurisdiction as provided in Article 139 of the 1995 Constitution. In addition to this, Section 3 of the Human Rights Enforcement Act, which is read with Section 2, describes this High Court as a competent court. However, my lord, my clients are asking for a compensation of 70 million, which exceeds the pecuniary jurisdiction of the magistrate's court. I will. Which law did the human rights enforcement? I believe my lord that Article 139 is more relevant to why we are in this particular High Court.
All right, fine.
Without further ado, my lord, I will handle issue 1, which is whether the exclusion of people with disabilities into the alternative classes and the imposed financial burden on their parents violates Article 21, 30, and 35 of the 1995 Constitution. My lords, my arguments will center around Article 30, 35, and 21. For my first argument, my lord, it's the applicant's contention that the respondents violated Article 30 of the 1995 Constitution. Education is both a human right in itself and an indispensable means of realizing other rights. My clients assert that the respondents, in taking them to alternative classrooms, did not cater for Article 30, my lords. In addition to that, my lords, our Constitution provides that they have a right to education, and this has not been fulfilled in this regard. At Article 24, under the United Nations Convention for the Rights of Persons with Disabilities, it provides for inclusive education for my clients, my lord. However, in paragraph 9 of the facts, my clients were taken to alternative classrooms, and at last they were offered outdated means. rights of persons with disabilities.
Okay. So you're relying on Article 24 does that convention. Is this court, can this court, sorry, is obligated for?
It is not obligated, but I first stated Article 30 of the 1995 Constitution, which is a right to education. Article 24 is just a supplementation to the Article 30 of our Constitution. It provides for inclusive education for persons with disabilities, my lords. Inclusive education is not about separate rooms as evidenced in paragraph 9 of the facts. It is not about outdated learning instruments that my clients are provided with. Since our books of law do not define outdated instruments, with reference from the 4th edition of the Black's Law Dictionary, outdated means something that is no longer in use. My lord, my clients are offered something that is no longer in use. Such means cannot involve inclusive education.
You're making very good submissions, but is the right that you're referring to an absolute right, and there are any allowance for exceptions to be made in some cases that it wasn't for the clients?
My lord, the right to education is not absolute. However, in this case, we argue that they were still discriminated in this right to education because some people were getting the education fully, but my clients were not getting it fully, like the rest.
Correct to that, but still the exception that in this case there was a reason as to why discrimination was made. So it just
The discrimination was happening against my clients. It would have been good, but they were not getting the same standard. Other students were getting only artificial intelligence material, but my clients were offered outdated learning material, which is therefore a violation of Article.
sorry for getting into your time, but you will get some point. You realize again you told us that the right is not absolute.
Yes,
The right to education is one of those rights classified as social rights, correct? The realization of which, again, is not exactly mandatory in the state. So there is a concept known as progress realization. Do you know about it? Great. So, again, if you are the school in this case and you're trying your very best to ensure that everyone in the household gets the education that they deserve, should be punished for it and be called discriminatory.
In this case, if I were a school, I should be punished for it. Because by giving other students things that are outdated, this means that they are not with the same quality. They're not providing the same quality education to both the students that are in the school. And with that, my lord, I will take us to in the matter of Ikoru versus Idiofu in the High Court. Court held, my lord, that it is the obligation of a school to ensure that they include the candidates' statistics, and excluding the candidate would be unlawful, unlike some circumstances. In this instant case, my lord, in paragraph 8 and 9 of the facts, my clients were told that they were going to be, their national statistics were going to be excluded from the national rankings of the school. This is unlawful, my lord, as this is discriminatory and this is not inclusive education. I will proceed to my second argument. The applicants aver that their right to respect and dignity was violated contrary to Article 35, Clause 1 of the 1995 Constitution. My lords, this takes me to the fact that in paragraph 9, my clients were taken to alternative learning classrooms. They dreamed of growing and laughing alongside their peers and growing in their academic life. But when they were taken to these alternative classrooms, where they were termed as the left behind class, my lord, this was not really good for their dignity and their respect, contrary to what our Article 35, Clause 1. In addition to that, my lord, the respondents...
What would you suggest this school do? Because the other alternative would be they don't study at all. So if the school is trying, at the very least, I would say this is just an occupational hazard. That, true, that there is going to be some, you know high school students. They're going to laugh at you, they're going to laugh at the class in which you are. That's just part of the daily grind of being in high school. better than not studying at all, would you fault the school for putting some, for trying? Would you extend them some grace?
My Lord, I do find the school at fault because they did not follow Article 21 of the 1995 Constitution, which states that the school is supposed to provide equal protection in all spheres for persons with disabilities. In this case...
So just a minute. So you said Article 21 of the Constitution,
Yes.
right? Does Article 21 create obligations on the school or on the state?
On the state, but in this case, the state is working through Nakaseke Bright Future Secondary School because Nakaseke is a government-aided school.
Yeah, so in that case, okay, so the government is helping the school, so you're suing the school, not the state? Don't you think the school has no means, even if it tried? I mean, they have tried, they have told you, we are waiting for the state. So don't you think the best person to really fault would be the state, not necessarily the school?
I believe both are at fault because in this case, the school also failed to ensure protection for the people with disabilities in all spheres of life.
Okay, so give me a practical, practical scenario. What would you do if you were the school?
My Lord,
Within the means, because remember, they don't actually have money. There's no money, what would you do if you were the school?
if I were a school, I would ensure that the students are able to study all together with the others because it fulfills Article 21, Clause 1 of the 1995 Constitution. In addition to this,
wouldn't that be resolve still the discrimination because you're making them study with other students who have no disability, right? Meaning the learning mechanisms that are going to be applied will be similar across the board. But you also recognize that these individuals have disabilities that then require them to have specific attention. So how then do you balance the two, having them studying their fellow students and then also taking into account their limitations?
my Lord, I'm taking into account the fact that the students feel like second-class citizens in this alternative learning rules, meaning that there is psychological torture, hence they cannot actually study, despite the fact that the alternative learning rules are supposed to be for study. In this case, it is better that we contain the students with disabilities with the rest and cope up in the artificial intelligence, as they will feel together, hence they are able to actually realize their full academic potential where they don't feel stigmatized, my Lord.
Okay, your time is up, but you can take a minute and just conclude your...
My Lord, it is our prayer that the court holds the respondents with a compensation of 70 million to the applicants. In addition to this, a public apology for the psychological torture that they caused to my clients, making them feel like second-class citizens in their own school and being referred to as the left-behind class, my Lord. It is so our prayer, much obliged, Your Honor, I submit.
Ladies and gentlemen of this honorable court, my lords, and our land friends for responding. As earlier introduced by my co-counsel, I am Muzachi Alana Chirabo, addressing issue 2. I am here to demonstrate, my lords, I am here to demonstrate that the collection of biometric and personal data without consent violated the right to privacy. Under this issue, I'll be fronting 3 arguments. Argument 1 is that the collection of biometric and personal data without consent violated the Data Protection and Privacy Act. Argument 2 is that the same collection of data violated the ICCPR. Argument 3 is that the respondent's actions did not pass the test of limitation under Article 43 of the 1995 Constitution. My lords, I will now proceed to my first argument. It is the applicant's submission that the collection of biometric and personal data without consent violated Section 8, Subsection A of the Data Protection and Privacy Act. As stated, no child's data shall be collected without consent of any parent or guardian. It is evident from paragraph 6 of the Act that Nakaseke Bright Future Secondary School under the Ministry of Education collected personal and sensitive data such as facial scan, fingerprint, and voice recording with no consent from its Yes, my lord, there are exceptions. The exceptions are under Article Section 8, subsection B and C, that it must be necessary to comply with the law and that it must be used for statistical research. But my lord, under my third argument, I'll be talking about why the...
You can address actually that argument as well. Yeah. So the answer to the question, please.
My lord, therefore, I will proceed to my third argument. In the Supreme Court case of Charles Onyango versus it was held that a limitation for any limitation to be allowed, it must be lawful. Number one, it must fulfill a legitimate aim, it must be necessary, and it must be justifiable in a democratic society. My lord, I understand that the Data Protection and Privacy Act are law and that the objective is education, but I will show that the third and fourth requirements were not met. Starting with the third requirement on necessity. In the Supreme Court case of Charles Onyango versus Attorney General, it was stated that for any limitation to be necessary, it must be proportionate. The respondents collected a lot of data which is more than necessary for education. Only the facial recognition.
Which part of the data was the AI one?
My lord, under paragraph 5, you can see that only the facial scans were accounted for. Not the fingerprints or the voice recordings were not accounted for. This concludes that they collected more than that was necessary for the purpose of education. Going on to the fourth requirement, that the limitation must be justifiable in any democratic society. My lord, which democratic society would allow excessive data collection of minors, worse if it's being stored in servers outside of Uganda? My lord, may I proceed?
Maybe just educate this course on how exactly this AI works, so that we can get a full picture of why it's wrong to take this data and why it's excessive. Because from what the court understands, and I believe probably the respondents would argue that this is very necessary data. You need fingerprinting for encryption. You need facial recognition for encryption. If you want to protect the data, you have to encrypt it in one word. If it's unencrypted, then it's going to be subject to abuse by the third party. So that could be, it's necessary. And you also argue that probably many countries do this anyway. So, and on the argument that you've just been making, that the data is stored on servers outside of the country, I would like to understand exactly how that is a problem. If within the country we do not have the facilities to store the data, wouldn't it be in the best interests of the young people that actually store the data in a place where it's going to be really secure? So could you just address us on that? How exactly does this AI work, and further buttress your argument on it?
The AI collected fingerprints, facial scans, and voice recordings. The AI has been known to make automated predictions, as seen in paragraph 6b, where some students were told that they would not pass the vocational training. The same AI works in a personalized way, as personalized tablets were given out, but people who could not afford these personalized tablets shared in groups of 10. But I think that the AI collection was not necessary because on many learning platforms, you log in with your email, with your credentials, not your fingerprint, not your facial scan, neither you wear.
But how this court understands AI is that AI works on data. It has to receive data. It has to get data. I believe that you are very. Have you addressed your mind to court case of New York Times against OpenAI? Have you? Yeah. So that was a case in the US where New York Times newspaper was arguing that the creators of ChatGPT had used a lot of data from New York Times, and they were using it in their own, to train their own model, ChatGPT. So when you ask ChatGPT a question, it can give you an answer, but part of those answers are gotten from New York Times. You understand? So how we understand this is that AI really works by getting information. It needs the information for it to work. Right? So if you're asking this court to bar the state and the school from gathering that information, then how will the AI work?
My lords, first of all, the data collection was not considered. Second of all, if this data was necessary, as the respondents were claiming it is, why did they account for the voice recordings? Why did they account for the fingerprint? If it was really necessary for the data to be used for education of the student, then I expect it to be explained in the case file, which it is not. So I assume that the data collection of the fingerprint and the data collection of the fingerprints and the voice recording was not necessary because it was not accounted for. And that's why my argument is it is not proportional because they don't make it clearly.
Okay. Please address your second issue. I believe you haven't spoken about it. Your second sub-argument.
My lord, therefore I'll proceed to my second argument. My second argument, which is that the Article 17 of the ICCPR was violated. My lord, Article 17 of the ICCPR provides that no subject shall be, no one's data shall be subject to arbitrary or unlawful interference with their privacy, and clause 2 obligates the state to protect data subjects and the applicants from such interference. As already demonstrated, the respondent.
There is a similar question that was asked you earlier. Why would ICCPR be applicable in this court? Like why are you citing why does it fall for this court?
The ICCPR is an international law and therefore persuasive in this court. As already demonstrated, the respondents did not care to obtain consent from the data subject's parents. My lords, I emphasize that consent must be specific. That means that me and bringing my child to school does not give the school permission to anyhow collect their data, especially since this involves AI, which is a high data security risk. My lord, it's therefore submitted that Nakaseke Bright Future Secondary School, Nakaseke Bright Future Secondary School, under the Ministry of Education and Sports, failed in its international human rights obligations.
Maybe before you take leave of that I'm just a little curious. Now that you're addressing privacy and that kind of thing, have you looked at the General Data Protection Regulations or the GDPR? You've looked at them? No, not the DPP. That's Uganda. There is a law in Europe called the General Data Protection Regulations, or the GDPR, which gives us some pretty good insights on what data privacy really is. And but even if you haven't gone that far, could you address? You've been mentioning quite a few technical terms, yeah. So could you perhaps define for us what a data subject is, or a data controller is? What are those entities?
My lords, a data subject is a person from which data is being collected, and a data controller is a person who is collecting the data.
Okay. And what exact obligations would you say a data controller has if they collect data? What is required of them to do?
They are required to provide adequate measures of protection. They are required to look for the subject's consent, and I think that those are the only ones that have really addressed my mind concerning this case.
Okay.
So
Right. Thank you.
before your time runs out, you mentioned something quite interesting. You said the school violated its international obligations under the ICCPR. Just help this court understand, is the ICCPR, does it bind the school or does it bind the state? And then in that case, who violated what?
The ICCPR is binding as it's international. It is merely persuasive.
To the court it is persuasive. But I'm saying, you made the statement that by the school not getting consent of the data subjects, it violated, should have been Article 17, I think, of the ICCPR. And my question is, can a private entity like the school be held to be in violation of an international statute, let me say? Is the obligation imposed on private entities, or is the obligation imposed on a state? Does it make sense?
applicable status is also applicable to school, meaning that the school and the state have failed to fulfill their international human rights obligations.
Okay. Thank you so much. Do you have, please make your reliefs.
Therefore, we pray that this court grants us compensation of 70 million Uganda shillings, and that the collection of biometric and personal data without consent is deemed to have violated Article 27 of the 1995 Uganda Constitution.
So maybe as before you run away, this 70 million you're asking for, what is it for exactly?
Throughout this whole drama, my clients have incurred a lot of mental damage. They have faced psychological and physiological torture. And so I'm just in 70 million, not only for compensation for the amount that they pay to cater for this AI, but also for their mental trauma and the hospital.
Okay. So do you really think, just this is off record, do you think that the school will be able to give you 70 million when it has been crying that it doesn't have money? Can this court give an order that would be very difficult, if not impossible, to fulfill?
I think that it can, because it has charged, let's say, over 70 students, 1.5 million shillings, and an additional 900,000 shillings.
So it can really afford the 70?
It really can,
Okay.
especially with the help of the state.
Okay, sure. Thank you very much.
This is Honorable Court, my lords. I am the same man of the head counsel together with co-counsel Mr. Lord, represent from the respondents in our secretary. We'll address two issues. One, I will address the issue in question, whether the measures taken for children with disabilities, including alternative classes and optional specialized devices, represent reasonable accommodation and progressive realization within the school financial and technical limits. I will address this under one head of argument, which is the right to education being subject to progressive realization based on available resources in 11 minutes. My co-counsel will address the second issue, which is that data collection is lawful, necessary and proportional and serves legitimate aims such as promoting education safely and preventing exam malpractices. We'll argue this in 9 minutes. Moving on to the first issue, which talks about education and discrimination. The first argument is on the right to education being subject to progressive realization based on available resources. My lord, note that we have Article 2 of the International Covenant on Economic and Social and Cultural Rights, which talks about progressive realization, that the state should take targeted steps on realizing education. We understand that states in themselves can have certain things like economic constraints, and therefore we don't expect them to be providing maximum education like Uganda providing maximum education that is provided in the state. Therefore, in pursuit for progressive realization, we give them some core time to provide some education in realizing the norms of education in a minimal time.
Counsel, we appreciate your efforts to progressively realize the right to education. However, there is a very important point that the applicants raise, which is, number one, you are giving these students with disabilities, you're giving them material that is outdated. Is that progressive enough for you? Do you believe it is?
I feel it's progressive in the sense that if we didn't give them outdated textbooks, the alternative would be them going back home to sit and sleep, which is not education at all. We think in progressively realizing education, we took steps in giving them alternative classes where they had AI-generated content and alternative material that provided basic education, progressively realizing the right to education.
So there is something also, now that you've talked about Article 2 of the ICESA on progressive realization, that article also creates certain obligations, yeah? Before you do progressive realization, there are certain things that you're supposed to do. Regarding the right to education, what are those things, and has the state done those things?
There are two factors under which the progressive realization cannot relate. The one is education being non-discriminatory, right? We feel in our sense, education was not discriminatory at all.
No, it's not really the discriminatory nature per se, but there is something called minimum core obligation. Have you ever heard of those?
Yes.
What are the minimum core obligations regarding the right to education. And in this instance, have you fulfilled those minimum core obligations?
Yeah, the minimum core obligations are simple. Providing these students with this education on a comparative of them not getting education is that the alternative classes we gave them were tailored to their needs because they needed to understand the reading, and the classroom was tailored to their needs. The smart class AI that was introduced was not in any way meeting their needs because it didn't have special screens that they could use in order to interact with the same class.
I'm finding it hard following that argument, because if it's true that these alternative methods were tailored to their needs, if that was true, then you would see better education among those students. In any case, you wouldn't have to blot out their names from the national register so that you do not shame the government and the school, the statistics. You don't want to blur the statistics. So my understanding is that whatever alternative education you were giving them was probably not as sufficient as you're making the court to believe.
Okay, I think the alternative, therefore, the whole cause of the problem was the introduction of smart class AI. By paragraph 8, it explains that smart class AI is still in its pilot phase, and international suppliers have not yet localized software for disabled learners in this case. Since it is under pilot phase, no one has ever implemented it. We expect such mistakes to come along in the process of discrimination, and we don't think no discrimination happened even if applicants argue that, because it is not the school that discriminated, it is the students.
So you agree that indeed there was some kind of discrimination?
We agree that indeed students felt bad, but it is not the blame of the school, because we tried to
Yeah, they felt bad, but why did they feel bad? Because the argument of the applicant is that this whole feeling bad is as a result of the discrimination itself, right? And they argued quite passionately, Article 21, they said, see, the Constitution says you shouldn't discriminate. And maybe if I could just pick your mind, would you say that there is certain circumstances in which discrimination may be allowed?
Yes.
Which circumstances are those?
I think under circumstances of fulfilling the public interest. That is, in instances where the interest of the public society achieves success of the school, the school itself wants to get fame and more students. Under those circumstances,
so you can discriminate.
Allow discrimination.
Have you looked at Article 43 of the Constitution? Did you?
Yes.
What does it say? Did you have a copy of it? Yeah, could you just pick it up and read it?
Just a second. Yes.
43.
Article 43. The general limitation on fundamental and other human rights and freedoms. I'll quote close to subsection C. It guides on how rights should be limited. It guarantees that public interest under this article shall not permit any limitation of the enjoyment of the rights and freedoms prescribed by this chapter beyond what is acceptable and the most
that is to see you've jumped the gun. If you read Article 43, let me read it for you, because I would like for this to also be a learning exercise. So Article 43 says, in the enjoyment of the rights and freedoms prescribed in the chapter, no person shall prejudice the fundamental and other human rights and freedoms of others or all in the public interest, right? And then 2, it says, the public interest under this article shall not permit political persecution, detention without trial, any limitation on the enjoyment of the rights and freedoms prescribed by this chapter beyond what is acceptable, okay? Then, when you go to 44, okay, because 43 leads you into 44. 44 tells you notwithstanding anything in the Constitution, there shall be no derogation from the enjoyment of the following rights and freedoms. 1. Freedom from torture, cruel, inhuman, degrading treatment and punishment. 2. Freedom from slavery or servitude. 3. A right to fair hearing. 4. A right to an order of habeas corpus. Right? So the question that I asked you was for you to give us that limitation that the applicants argued quite passionately, by the way. They said that the 4 aspects in Article 44, no, Article 43, those and which are also given in Charles Onyango Bill, 2 of them were not fulfilled. They said necessity and what was the second one? They said that it did not fulfill necessity and proportionality. Okay, so explain to this court.
I'll start with necessity.
Yes.
In this case, again, we assert that it was necessary for these students to still follow education and get classes where they could receive this education. It was proportionate to their needs because under that system they could still get education. In a class where smart class AI was still introduced, it wouldn't be proportionate because there still is no way in which those students can study. So for terms of proportionality, the alternative class makes it proportionate. The second, which is interest, right? I think in interest of the learners, their interest is to receive education at the end of the day. Bare minimally, basic education as described by progressive realization of education by the state. We provided them with bare minimum education, at least that they could get some education, they could be able to read and write as a state. We think in interest, they have interest of.
Would that education you provided them be enough to put them at par? Yeah, I'll give you an extra minute. Would that education given to them be at par with their peers? Because the whole idea is that they should, in the very least, be at par with their peers, in one way or the other.
They would be at par with their peers because since this is still still a pilot project which someone has never interviewed.
They would be at par. Why then do you feel it necessary to take them off the school records?
We feel in interest of public, in the pursuit of public interest, taking them off the records in the meantime, which is a temporarily change, makes it important in the progressive realization of education.
Does it really? Does it? Do you feel like by taking them off the record so that the results do not reflect badly on the school is in fulfillment, one, of public interest, but also secondly, it's in realization, progressive realization of their right to education?
Yeah, because I think if it is a pilot project and a temporarily smart class AI, with time, if there are problems with it, we can find means that come along with it. Because paragraph 9 also talks about the idea that I think paragraph 8 also explains that the international suppliers have not yet localized software for the disabled learners, meaning in the next phase of the implementation of the pilot project would be in best position to provide these learners with a smart class AI that helps them with their needs.
Right. Thank you very much for your very passionate submission. You can now hear from your colleague.
May it please this court, for purposes of records, my name is Melissa Joel, co-counsel on the respondent side, and I'm going to argue on issue 2 on the respondent side under one head of argument. That issue 2 is the data collection is lawful, necessary, and proportionate and serves the legitimate aims such as promoting education safety and exam malpractice. The first head of argument. The right to privacy permits lawful proportional limitation for direct interest. Yes. I'll quote Article 43, limitation of rights limitation of fundamental and other human rights and freedoms. Clause C, Clause C and subsection C, Clause 2 and subsection C, guides on how rights should be limited. It guarantees that public interest under this under this article shall not permit any limitation to the enjoyment of the rights and freedoms prescribed by this chapter beyond what is acceptable.
Pass the laws.
Yes, my lord.
There is an argument that one, you didn't take consent. You didn't ask for consent when you are collecting this data. What justifiable reason do you have for doing that? And secondly, they also argue that the data that was collected was more than what was necessary.
Yes.
Just address us on those two heads of arguments.
First head of argument, without the consent of their parents. Yes, we admit we collected this data without the consent of their parents or guardians. But then we think, it is acceptable and demonstrably justifiable in a free and democratic society. Why do we collect this data in the first place? Firstly, we have to maintain exam integrity. We do not want these students to, in the first place.
What injustice would you suffer by asking the parents to give you consent for their children's data to be collected? Would it in any way jeopardize that consent? Would it in any way jeopardize the examinations that you're speaking about?
Yes, consent is twofold. Firstly, they could give in the consent or even refuse to give in the consent, but it's for public interest. That is to say, the parents could in and of themselves.
Had they refused to give you the consent, had you asked them and they refused to give you the consent, those are, I guess, are also two different things. Did you try and they said no, hence you proceeded to say, in the interest of the public, we will proceed to collect the data anyway? Did you try? Because in this case, it seems like you just decided to proceed with it. Because you see, for you to say it's demonstrably justifiable, you must at least show that there were efforts that had been undertaken to either get the consent or show that the getting of the consent would impact your examinations or whatever it is negatively. So in this case, what was that reason for you to skip the requirement on consent?
Okay, as lead counsel said, this is a pilot project. We expect imperfections here and there, and we promise that in the next phase we are going to better up this. But then the taking of this biometric.
So is that an admission that indeed you violated these people's right to privacy?
Yes, it's an admission that we violated these people the right to privacy, but then we think it is justifiably and demonstrably acceptable in this.
But then you see, you cannot violate and then you say, but it is justifiable. Once you say that it's true, we violated the right, that in and of itself, the court then ends and we award them the 70 million and everyone goes home. Because you've just literally told us, yeah, we actually did, we violated. It's an admission. Unless, of course, you say we limited the right, okay? But we have actual reason why it was limited in this instance. And that actual reason should take us to the exceptions that the applicant argued. Because the applicant argued that there are exceptions to collecting data, okay? Still under the DPPA, under Article Section 8, there are actual exceptions. So could you address us on those exceptions and how exactly you fall within that exception?
If you don't mind, pardon me, my lord.
The applicant argued that under Section 8 of the DPPA, which provides for consent, there are exceptions to it, right? And those exceptions are still found under that, you know. So could you address the court on those exceptions and how exactly your client falls within those exceptions?
Yes, the biggest exception is for public interest, right? If at all our action is for the betterment of the education service that we are in and of ourselves ushering in, and it's for the betterment of the public interest in those kinds of regards, then we think we are justified to limit the right to privacy and to limit the right to privacy and the fundamental human rights of these individuals, my lords.
Yeah. Let's just look at that. So I believe you probably hadn't properly addressed your mind to that, because this is a very important point, especially dealing with minors. the data of minors is quite sensitive, and you want to protect them. So if you look at Section 8 on personal data relating to children, okay, you are not allowed to even collect that data unless there is one prior consent, okay, of the parent or the guardian. Okay? 2, it is necessary to comply with the law, so there must be a law that is telling you you must collect this data.
Yes, my lord.
Okay? And 3, it is for statistical and research purposes.
Yes, my lord.
The wording of these 3 is in fact cumulative. It's not that you can fulfill one and then leave the other.
Yes, my lord.
Right? So in this instance, you did not get prior consent
Yes, my lord.
of the parents.
Yes, my lord.
And you have said that is because?
It's because we want to better up the... No, it was under 2 folds. Firstly, it is a pilot study. We expect imperfections here and there. But then secondly, why we then limited the right to, privacy and data protection is because it is for the betterment of the, of the education system that is provided. We want to better it up, and we need this information to firstly gather up their attendance and even exam integrity in those kinds of instances.
I'm finding it a bit hard to follow that argument. A little hard. You say it's because you want to better the program, and then secondly, because a pilot study.
Yes,
none of these is an exception. None of them at all. In fact, if anything, they are the very same reasons why you're supposed to get that consent. Because a pilot study, by its nature, is experimental. So you need to get the consent of the parents before you can experiment, because anything can go wrong in these experiments. Secondly, you want to better the algorithm using children's data. As a parent, I would like to know exactly how my children's fingerprints are really going to better your algorithm. Without them, you can't. You may need to explain it to me properly so that I can understand it, which I think is the whole reason for getting consent, don't you think?
Yes, I think so. But then when this program was introduced in this school, parents welcomed it with warm hearts and, with regards, because it had shown drastic.
So there is constructive consent. The fact that they were happy with it shows that they were.
But then secondly, because it is for statistical, information and storage, we need to follow up these students' performances. We need to follow their attention in class and attendance, so that justifies us to limit the right to privacy and even consent of these very individuals and these students.
Yeah. So address the argument of the applicant on restriction using the Onyango-Bo criteria that they set out.
Restriction using the...
Yes, because they set out the case of Onyango-Bo. You've read that case? Oh, you haven't. So that case establishes restrictions in which instances can you restrict certain rights. And they said that, yeah, the state may have fulfilled the first 2, but the other 2 are problematic. And they raised the question of proportionality.
Yes, my lord, and necessity.
And necessity.
Yes,
okay? So address us on those 2. And as you do so, I don't know if you've read the GDPR that I asked them about, the General Data Protection Regulations of the EU.
Yes, my lord.
You have looked at them, so you can put that, your answer, bundle both of them together. So you can tell us what the GDPR says and your argument on those 2 key issues.
First key issue is on necessity. We see it is necessary for the new education. My lord, my time is up. I would request for more 5 minutes.
No, 5. You have 2. 5, my friend. 5 minutes is a lot.
Okay, thank you.
You have 2.
In those 2 minutes, let me address the issue of necessity. I find it necessary for this school and institution to take up and take that information, personal information and data of these students. Why? It is for the betterment of this education system. We need to follow up their attendance, we need to follow up their attention in school, but then more so, we need to follow up things like examination integrity, and that's what is necessary for an education system to be effective, and that's what we want in the first place. But then secondly, on the idea of proportionate, was it proportionate then? They are asking that, was it proportionate then for us to take the data without their consent or without the consent from their parents or guardians? I think it is proportionate because we have to follow, because it is for the public interest, as I earlier explained, and there was no way we could execute all these flows, execute all these proceedings without the collection of that data. It is necessary and it is proportionate. But then more so, my lords, we think this is a pilot study. We expect imperfections here and there.
I'm sorry, I know your time is fast spent. However, on the point of the collection being proportionate to the use of the data,
yes,
the argument was you collected much more than would be
necessary.
Yes. Just address us on why for you think the amount of data that was collected in this case wasn't much more than what was actually necessary.
I think the fingerprint, I'll just explain what each kind of information
exactly.
is necessary.
Yeah, that's what
the fingerprints are in and of themselves to get the attendance. Facial scans are for attention in class because that's what the clause under facts, under paragraph 2 status. They say that the fingerprints and facial scans were taken without the consent of these parents. Fingerprints were just necessary for the attention, for the attendance as a roll call, then facial scans for the attention because we get to know that this is an AI. It has to do with things like gadgets. So a lot of diversions and a lot of diversions for things like attending to what the education system would require. But then we need these fellow students to take us to just take a step more formative and then go on to and attend the lessons and attend the education programs, my lords.
Right.
So if there are no further
please
questions,
give your prayers.
we pray, my Lord, that this court does not hold the respondents accountable to pay 70 million because we explained to you that the need that why we limited the rights of these people is proportionate and it was necessary then. But then also we pray that this court does not guarantee the respondents a public apology. But then also we find it misleading for the applicants to come and argue that the school has enough money, the 1.5 and the 900,000 they are collecting from the students, because that is to implement and ensure that every child gets this kind of gadget, not for the school in the first place. So yeah, if there are no further questions, allow me to give the floor for the next speaker. Thank you.
All right. Thank you so much. I was advised that you have some points for rebuttal.
My lords, whereas the respondents argue that their actions were out of progressive realization is not disparity in standards. It is not taking my students, my clients into these alternative rooms and giving them outdated material. This defeats progressive realization and goes against Article 35, Clause 1 of the 1995 Constitution. In addition, the respondents argue that removing my clients from the national ranking statistics of the school is out of public interest. But my lord, in the matter of ICORU, the High Court matter of ICORU versus the Board of Governors of Ediof Secondary School, the court held that where the statistics of certain students have to be removed, this is unlawful, my lord, and this is what the respondents did to my clients, my lord. It is therefore so our prayer that the respondents are held accountable for going against Article 30, 35, and 21 of the Constitution, my lord.
Right. Thank you so much for that rebuttal. I believe that now we have come to an end of this round, and we will be giving a few brief remarks before we can proceed to the next. We are going to give a few remarks, and then that should help you proceed to the. So I'll let my colleague first give his remarks, and then you can give us as I'm writing.
Okay. Thank you. Sorry, what school? Ontario. Okay. All right, as my colleague fills up his form, thank you so much for the session. It was a good one, and I know how nervy sometimes it can be to participate in some of these things, but I think you all did great. You answered the questions, you didn't let them slip, which is also good. Of course, we have different criteria that we use for ranking who said what and whether what you said was persuasive enough, but the mere fact that you answered the questions is good enough, right? It's a good start, that is. Just feedback to both teams. So when the judges normally are asking you questions, in most cases, it's because they want to lead you to a certain direction, and they want to hear that exact thing that they're asking for, right? Now, I know when you're preparing, normally you have everything set out in a straight line. I'm going to say this, then after that I'll go to this. But I think you saw when some of you came and then we told you start with your second or third argument, or let's go this other direction instead of what you have prepared for. So the expectation from us is you should know your case in and out, right? If we require you to take a different direction, it shouldn't be very difficult for you to switch to that direction and then come back to your line of argument that you were making originally. So it's important that you are one and part of your case, right? Then still on us leading you to where we want you to go, you are answering, some of you are answering the questions again from the perspective of this is what I have prepared. But if we are asking and we want you to tell us about the exceptions, go directly to the exceptions and, tell us what the exceptions are, how they apply to your case, etc., etc. So you have to be very keen on what the judges are telling you. Then the other one, again, I know at your level, perhaps you haven't interacted very much with some of these laws. We were asking you questions around international law, the ICCPR, ICSR, and their application. But you have to keep at the back of your mind that in this case, the state signs onto these agreements, right? It's not private entities, so you cannot hold me accountable for what the state has decided to sign itself up to, unless you can make the argument that I work on behalf of the state, or I and the state are one as a private entity. Okay, so those are some of the things that you have to take away for your next rounds. But otherwise, I think, yeah, you did fairly well. One last thing, maybe before David comes in, you carry your material with you, which it's not a problem, right? It's not a problem, but we also wouldn't expect you to be reading of it, because sometimes it can actually disorganize your flow. Going back to the first point that I made of you being one and part of your case. So if you're reading from your paper and then I lead you to a different direction that is not on your paper, you realize that you have to start flipping pages, and can actually make you lose your train of thought. So just embrace your case, okay? Yeah, thank you so much.
Right. So I took note of a few things that I thought were important. So for an exercise like this, of course, we do not expect you to know all the law like lawyers would, know everything offhand. But there are what we call the bare minimums, the small, tiny things that either show that you have done more than just preparatory reading, okay? And you kind of understand a little bit some of this. So some of the questions that I was asking were more taking you to the bare minimum, okay? So have you understood that concept? It seems easy, but it has a whatever to it, right? So what I always would say, even in other moods with lawyers, would be always pay attention to the bare minimum. Those simple, tiny things that seem very easy to just pass by. Pay attention to them, okay? As for example, questioning, I liked how the applicants brought in the question, the argument of jurisdiction, saying, no, bring this case under Article 139 and, the Human Rights Enforcement Act. There is, in fact, a part of the Constitution that directly speaks to the Human Rights Enforcement Act, right? The article from which the Human Rights Enforcement Act was, in fact, made, and it's not 139. So 139 is about the High Court. Beautiful, amazing, but there's somewhere it comes from. Yeah. So I'll not spoil your reading. You can check it out as you go about your whatever, and perhaps you would address your mind to it. Of course, that does not affect your performance per se, because even some lawyers don't know where the Human Rights Enforcement Act comes from. So it's one of those things that would make you excellent. Now, the performance is outstanding, but as they say, in a room full of mediocre people, any action above average is excellent. Yeah? So where we expect all of you to have all these laws and all these good things, that those tiny things, when if someone knows it, you're like, ha, yeah, that person did their work. They did more than just a few whatever. The other thing that my colleague has just talked about is the application of the laws. You know that courts work with law, yeah? Please be very careful if you make if you go more than 2 sentences without referring to a law. Yeah, that law can either be the actual law, a constitution, a statute. It can even be case law. And sometimes it can even be, writings. Someone has written about this somewhere. It's very, very important. We thrive on authorities, okay? So if you can add a few of those, you'd be absolutely good. The other is it's called ingenuity. So ingenuity is the ability to think on your feet. Yeah? When you come to a moot court, and in fact, court itself, you are expected to think on your feet. There are certain questions you'll be asked when it just needs you to think outside the box. And I believe both of you teams have done a pretty good job with ingenuity, but it could be improved, okay? That can be something like giving an alternative argument, all right? This would especially be good for applicants, when you suspect that the respondent is going to make an argument, and that argument is going to make your case weak. So what you do is you address that argument before they bring it on. So while the respondent may argue this, this is what we say here. So by the time we get to the respondent, we now have questions for them. The applicant said this. So what do you say now? You get. Those are called alternative arguments, and they are really, really good. For the respondent, it's always good for you to attack the argument of the applicant head on. Don't run away from it. As the applicant is speaking, if you notice, most of our questions are like, the applicants argued this. What do you say? When the applicant is speaking, pay very keen attention to what they are saying, because you are responding to their arguments. Okay? So if you do not pay attention to their arguments, it's going to be very hard for you to respond, because you come with your own arguments, and then the court is asking you, but that's not what the applicant is saying. The applicant is saying something entirely different, so what do you say about that? So you need to have that at the back of your mind. So be very attentive as they are speaking, and as a respondent, attack their argument directly. Start with their strongest argument. This is the basis, the crux of the argument is this, and this is what we are saying. That would not be applicable, or that is not the case, or they are misrepresenting the facts, or they are lying to the court, etc., etc. Yeah? But that's what a good respondent does, okay? Then lastly, this was on concessions. I got this a lot from the respondent. don't just concede. Now, concessions are good, but they have to be tactical, okay? You have to be very careful before you concede on a point. Yeah, sometimes judges will ask you a question just to help you argue it better. Not that they want you to concede on it, they want you to argue it better. So they are trying to see whether you can really think, pull it out, the rabbit out of a hat. You know, I think the first respondent did that really well when I took him to the question of derogations. You know, Article 43, what do you think? And he quickly figured out that I'm trying to drive to discrimination on whether or not it is derogable or other ones, right? So that is, so you don't just concede on a matter quickly, yeah? You first listen. Sometimes if the question is unclear, you can ask the judge to rephrase it as you're thinking. Could you rephrase that? Could you rephrase that question as you're thinking? And then find an ingenious way of making your point without necessarily conceding. Only concede if you have a better argument. So you may concede on one part, but then now advance your argument on a much more important part. So for example, you could concede that, hey, yes, there are four aspects of whatever derogation, right? That Onyango both says. However, on the first two, yeah, probably there might have been some issues, but on this other one, or if I ask you a question on Onyango Bo and you didn't read it, you don't say, no, I didn't read that case. You say, I may not have addressed my mind to that, but I addressed my mind to this other case. Or there is this other authority that would make my point for me. So you concede that, yes, you did not read this, but you have something better that you're going to offer the court. You understand? So that's what we call a tactical concession. Concede on one, then get them the other side, okay? So those aspects, I believe would make an even better round, but this was a good round. I absolutely enjoyed it. Some of you guys argue better than some law students that I've actually met. The arguments we were making, I was thinking, how did you learn this in high school? Man, for us when we were in high school, we were trying to fight not to be suspended from school. But you guys have done a really good job, and I'm very exceedingly proud of this round, okay? So good luck in your next rounds, and yeah, this court is now...
Other updates to come.